The Alexander brothers agreed together to traffic, rape, and sexually assault more than over a decade, multiple women.
The prosecutors who filed federal sex trafficking charges against three brothers, Oren, Alon, and Tal Alexander, want to keep certain personal information about alleged victims and or witnesses confidential. But attorneys for the Alexander brothers say this proposed order is way too broad, has to be narrowed down before the judge can approve it. We're going to take a closer look at arguments from both sides. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. The Alexander brothers are fighting back against allegations of sex trafficking and sex trafficking conspiracy, but their legal teams say if they don't get certain information and discovery from the prosecution, they won't be able to put up a strong case. And they argue that what the prosecutors are doing here isn't even constitutional. Now, when we talk about the Constitution here, and we're talking about a criminal defendant's rights, aside from due process rights for a second, really, more specifically for this issue, we're talking about the Sixth Amendment. So, Sixth Amendment, a criminal defendant has the right to a speedy trial, a public trial, counsel, but also a right to an impartial jury, a right to know the charges being alleged, the right to confront witnesses testifying against them, to have witnesses who appear in their favor, and perhaps that's also to suggest providing these witnesses full information so that they can properly testify on a criminal defendant's behalf. I want you to keep all that in mind. Now, it has been a minute since we've talked about Oren, Alon, and Tal Alexander. So here's a quick rundown of what you need to know before we get into all this. So Oren and Alon are 37-year-old twins. Tal is their 38-year-old older brother. Oren and Tal, they ran this wildly successful luxury real estate empire in New York and Miami. Alon works for the family's private security business. They are very well known, very wealthy, very connected. But all three have been locked up for weeks after federal charges were filed against them. By the way, the twins, they also face state charges in Miami-Dade County for alleged sexual battery. Now, the brothers have asked for bail. They've offered up hundreds of millions of dollars in collateral, offered to hire a private security firm to watch them 24/7. But during hearings addressing pretrial release, the prosecution pointed out that these men have allegedly engaged in deceptive and vile conduct for decades. Plus, their substantial wealth, resources, all make them potential flight risks. So you couple all that together, and according to the court, they met the criteria for being denied bond. And I want to expand upon that because after hearing from both sides during a recent hearing for Alon Alexander, Judge Eduardo Sanchez acknowledged that denying bond was a difficult decision, but ultimately ruled that the risk of flight was just too great here for Alon Alexander. He noted that the brothers' vast financial resources, their strong ties to Israel, made it likely that they could attempt to flee the United States. The New York Times also reported that Judge Sanchez was also concerned about a, quote, two-tier system of justice, one for the wealthy and for those who are not wealthy. And while the counterargument to that would be, and this was something that was argued in Sean Combs' bail application out in his criminal case in New York, the reason we're putting together such an expensive and expansive bail package with millions and millions of dollars in collateral and private security, and even though, other defendants of lesser means couldn't put something like this up there, we are only doing this to combat the concerns that were put forward by the prosecution. That, look, we have the power and resources to flee. Well, I'll tell you what, the response would be we're putting in these kinds of measures to ensure that doesn't happen. Now, that argument wasn't successful in Sean Combs' case, and while I'm not entirely sure it was argued like that here, Alon Alexander was denied bail nonetheless. By the way, I know that we're dealing with some pretty tough subject matter on here, and it kind of puts a spotlight on the struggles that people might be having. And there's no shame in that. There really isn't. I mean, who doesn't want to be the best version of themselves? So with that in mind, I want to tell you real quick about our sponsor, BetterHelp. BetterHelp is fully online therapy. They've made therapy affordable, convenient, easy, which makes sense considering they're serving now over 5 million people worldwide. And it's not just about trauma. It's about navigating relationships, life choices, just understanding yourself. And by the way, with BetterHelp, if something isn't working out, you can easily switch therapists at any time at no extra cost. So right now you can visit betterhelp.com/sidebar today to get 10% off of your first month. That's BetterHelp, HELP.com/sidebar. Now, I want to go back to something because it's actually going to come up in our conversation a little bit later. But during a news conference back in December where the prosecutors announced the charges against the Alexander brothers, former U.S. Attorney for the Southern District of New York, Damian Williams, laid out these egregious allegations against the brothers. Take a listen.
As alleged, the defendants used their wealth and positions to create and facilitate opportunities to sexually assault women. In particular, Oren and Tal Alexander allegedly used their prominent positions in the real estate industry to induce women to come to events and parties. At those parties, and sometimes afterwards, the women were sexually assaulted by one or more of the defendants. As alleged in the indictment, for years, the Alexander brothers, sometimes with others, also arranged domestic and international trips to carry out their sex trafficking scheme. To recruit and induce women to come on the trips, they provided material benefits, things like travel to vacation destinations, luxury accommodations, and access to other high-end experiences. As alleged, the Alexander brothers met their trafficking victims through a variety of means: in person, over social media, on dating apps, and through social connections. At times, they allegedly used their social connections or the guise of starting a relationship to lure women into their orbit. The indictment alleges that after meeting their victims, the Alexander brothers would invite the victims to a vacation property or location. The Alexander brothers and other men they planned the trips with paid for the flights or accommodations for the women on these trips. And at times, the defendants handpicked the women to invite. At other times, they used paid party promoters to source women for them. The indictment also alleges that in advance of these events, the Alexander brothers and others procured drugs that they agreed to provide to the women, including cocaine, mushrooms, and GHB. As we allege, these drugs caused some of the women to be physically unable to fight back or to escape. Then, as alleged, the Alexander brothers, sometimes acting alone, sometimes with each other, and sometimes with other men, forcibly raped and assaulted the women. As the indictment alleges, the Alexander brothers' sex trafficking agreement went beyond the planned trips and events. On numerous occasions, one or more of the defendants drugged and raped or sexually assaulted women they encountered by chance at bars, at nightclubs, social events, and dating apps. These assaults allegedly had many of the same hallmarks as the rapes that occurred at group events: isolated locations, drugged victims, force, and physical restraint. As of today, law enforcement has interviewed dozens of women who reported being forcibly raped or sexually assaulted by at least one of the Alexander brothers. This conduct, as alleged, was heinous. I stood here several months ago and made clear that this office is firmly committed to prosecuting individuals who exploit and abuse women. I meant what I said. With our law enforcement partners, this office is determined to investigate and prosecute anyone who engages in sex trafficking, no matter how powerful or wealthy or famous you may be.
Again, keep that in mind. It comes up later. But this now moves us into what we want to talk about right now. So last month, prosecutors with the Southern District of New York filed a request for the judge to approve a proposed protective order, which they say would protect alleged victims in this federal case. Now, it is designed, a protective order, to keep certain material confidential or sealed or limit who sees it as a way to protect the safety of alleged victims, witnesses, to ensure the integrity of the proceedings. And now we have a response from the brothers, from the defense, and they are not happy. But to understand what they're talking about, we got to go back to what the prosecution offered, the prosecution's letter to the Honorable Judge Valerie E. Caproni. And it reads in part, quote, "The government believes that a protective order is necessary in this case, given the nature of the charges and the sensitivity of the evidence that will be provided during discovery. On December 11, 2024, a superseding indictment was returned by a grand jury sitting in the Southern District of New York, charging 1. Alon, Oren, and Tal Alexander with participating in a sex trafficking conspiracy from at least 2010 through at least 2021. 2. Tal Alexander with sex trafficking victim 1 by force, fraud, and coercion in 2011. And 3. Alon, Oren, and Tal Alexander with sex trafficking victim 2 by force, fraud, and coercion in 2016. As part of their sex trafficking conspiracy, the Alexander brothers engaged in a persistent pattern of rape and sexual assault, which included both pre-planned trips and events for which the defendants recruited women to attend and then raped and sexually assaulted them, as well as opportunistic rapes and sexual assaults of numerous victims who they encountered by chance. To date, law enforcement agents have interviewed over 40 women who reported being forcibly raped or sexually assaulted by at least one of the Alexander brothers. The rapes and sexual assaults described by victims were committed between approximately 2002 or 2003 and 2021. In these accounts, each defendant has separately been accused of forcible rape by at least 10 women. So according to the government, the Alexander brothers have been allegedly forcing themselves on unsuspecting females since high school, even making jokes about alleged gang rapes in their yearbooks. And since then, the prosecution argues, the brothers have used their wealth and their influence in New York and Miami to lure women into dates that turned into assaults. Some of the alleged victims say they met one of the brothers on a dating app or social media. Others say they moved in the same social circles, went to the same events. The Alexanders reportedly used the promise of free flights, expensive vacations, gifts to get what they wanted. That these brothers are also accused of procuring illegal drugs, giving them to the women without their consent. And we also learned in the prosecution's opposition to bail in one of their filings that there is likely video evidence of these assaults. Quote, the government has adduced even more evidence of the defendant's criminal acts. On or about December 11, 2024, law enforcement agents executed a warrant to search an apartment in New York City leased by Tal Alexander. During the search, law enforcement agents seized numerous photos and videos depicting at least Oren, Alon, and several third parties recording or photographing themselves with women in states of intoxication and undress. In multiple videos, the women appear initially unaware that they were being recorded and became upset and attempted to hide or flee from the camera after realizing they were being filmed. In one video, the camera peeked over a bathroom stall where a woman and a man who is not one of the defendants are engaging in intercourse. When the woman looked up and saw the camera, she hastily began to get up, saying no, and stating in sum and substance that she does not want all of friends. Multiple other videos found in Tal Alexander's apartment depict Alon, Oren, and other men engaged in sexual contact with women who were visibly under the influence of alcohol or other substances. In some instances, at least one defendant and another man physically manipulated the women's bodies in order to have sex with them while the women did not actively participate in the sexual activity or turned away. In combination with the facts set forth in the detention letter, this evidence underscores the depraved nature of the defendant's conduct and the immense danger they present. Keep that in mind. Obviously important allegations for the bail analysis, but also important when we talk about what should or should not be disclosed in this case. And that does bring us back now to this proposed protective order, because they say, the prosecution, all of that backs it up. And they have listed out some of the items that they have in discovery so far in this case. Quote, the disclosure material in this matter includes, among other things, a substantial amount of electronic evidence, including data obtained from social media accounts, iCloud accounts, dating applications, emails, financial records, travel records, photos and videos, and electronic devices seized during the search of the defendant's premises. And they argue that potentially disclosing this material could affect the privacy and the confidentiality of individuals and entities. And if you disclose this now, it could affect an ongoing investigation into other people who haven't been charged yet. That the release could potentially prejudice a potential jury in the future. And the prosecutors also say you don't want to be in a position right now to be identifying these alleged victims or witnesses at this stage. That's the danger here. That's what they say. Quote, due to the particularly sensitive nature of the evidence in this case, including sexually explicit photos and videos depicting victims and other individuals, as well as evidence relating to rape and sexual assault, the entry of the proposed protective order is necessary. Okay, now as to the law on all of this, because you might be saying, wait, I thought in a case like this, the government has to be transparent about everything. Well, the prosecution cites the federal rules of criminal procedure and how on a showing of, quote, good cause, a court can in fact deny, restrict, or defer discovery or inspection of materials in a case. And here they say there is good cause. I outlined all the dangers, all the sensitive aspects of this material. And they say there would be 4 designations of evidence in this case. So you would have disclosure material, what can be turned over and seen, sealed material, that wouldn't be, attorney's possession only material, and attorney's eyes only material. And those last two particularly about how a defendant can maybe view or have access to evidence in this case. And for defendants who are accused of some pretty heinous and egregious conduct, what they can have access to, what they can see, the government seems to be arguing we got to make sure that the identities of these alleged victims and these witnesses have to be protected, that this information is not compromised in any way. Because let me give you an example here. And again, the brothers are innocent until proven guilty. They haven't been convicted. But let's say you have an example where you have a criminal defendant who finds out the name of an alleged victim or a name of an alleged witness, uses their power, resources, associates to try to intimidate that person from actually testifying. That's a worst case scenario. Not saying that's what's happening here, not saying that's what's being alleged, but obviously given the allegations, given the status of these individuals, that's a concern I think that's being brought up. But anyway, the prosecution's letter also says that the proposed protective order would not hinder the defendant's efforts to defend themselves at trial. Again, trying to assure that there's no constitutional violation. But having said all that, the defense strongly disagrees with the prosecution. So on Friday, attorneys for Oren filed a response, and Alon actually adopted the brief, basically co-signing it. And it reads, quote, "The government requested that this court enter a sweeping protective order governing the use and disclosure of discovery materials, requiring the defense to obtain signatures from all prospective witnesses and file those signatures with the court, and seeking in some instances to prohibit even the defendants from viewing their own discovery." So the defense's main argument is that the government hasn't shown good cause for such a protective order. And then they cite several cases that they argue provide guidelines for protective orders of this nature, including one that says broad allegations of harm unsubstantiated by specific examples or articulated reasoning do not support a good cause showing. And the defense argues that blanket statements like the government made or allegedly made don't cut it. Quote, "Courts in this district have observed that blanket or umbrella protective orders can be overbroad and unnecessary. And quote, as a result, umbrella protective orders are disfavored." So the defense says that the government's short letter here, only 2.5 pages, does a pretty poor job of backing up their argument for what the defense attorneys call, quote, "an overwhelmingly broad and unduly burdensome protective order." And to highlight a lack of specificity in the government's request, the defense writes, quote, "The government writes in its letter that the proposed protective order provides for 4 designations, but it doesn't identify which material corresponds with which designation and requests instead a blanket ruling that gives it unfettered discretion to hamper the preparation of a defense and attorneys' collaboration with their clients." So here the defense seems to be suggesting, hey, court, we're just going to take the prosecution's word on it. Yeah, you get all these designations, you determine what's sealed material, you determine what's attorney's eyes only material. That doesn't seem fair. That's what they're basically saying, or at least that's what it seems to me. And the defense also points out that the arguments that prosecutors rely on, that could really apply to any criminal trial. Quote, "The government says that its disclosure includes material that affects the privacy and confidentiality of individuals and entities. But that is true of any criminal case that, as many do, involve individuals and entities other than the defendant. Doesn't supply good cause for entry of a protective order, especially not one as broad and standardless as that requested here. The government does not identify whose privacy interests would be harmed, what privacy interests would be harmed, nor how such privacy interests would be harmed." Again, they're saying you need to be more specific here. And they also called out the prosecution for its pretrial publicity, like the news conference that I mentioned before with Damian Williams that he gave in December. Quote, "Second, the government argues that the discovery material would impede, if prematurely disclosed, the government's ongoing investigation of uncharged individuals. But as a result of the government's engaging in a highly prejudicial publicity campaign, which has included improper disparagement and demonization of the Alexander brothers at a press conference, any individual who ever socialized with the Alexander brothers is already on notice that they may be subject to the same treatment. The government doesn't explain what material may implicate other individuals or how the investigation would be compromised. The government instead appears to seek to block the defense from conducting a thorough investigation." In other words, prosecution, cat's out of the bag. The harm's already done. People that you might be investigating probably know that they're being investigated or are concerned that they're being investigated. Now, as to the argument that alleged victims and witnesses, that their identities could be revealed and that could subject them to intimidation and thus prejudice the integrity of the case, the defense's filing continues. Vague allegations that witnesses may be subject to intimidation does not establish good cause. So they argue that is very speculative. Next, their letter continues as follows. Finally, the government asserts that the protective order is necessary due to sexually explicit photos and evidence relating to sexual assault. Oren does not object to conditions prohibiting him from sharing sexually explicit images for purposes other than his preparation of a defense. However, To ensure his constitutional right to a fair trial, which includes the right to prepare a defense, Oren must be able to freely share material evidence with potential witnesses, experts, and even transcription services without being required to disclose attorney-client work product. The government's proposal that discovery disclosure be limited in some instances to any personnel for whose conduct defense is responsible is unworkable and overly burdensome. A defense investigation involves contact with many individuals without counsels assuming responsibility for their conduct. Surely the government does not assume responsibility for the conduct of every co-conspirator they interview in connection with a drugs and firearms trafficking investigation. The government's proposed protective order further and significantly hampers that preparation. So going back to the Sixth Amendment and the Sixth Amendment rights, the defense here, they cite case law for the following propositions. Quote, "The Sixth Amendment does not provide merely that a defense shall be made for the accused. It grants to the accused personally the right to make his defense. The right to defend is personal. The defendant and not his lawyer or the state will bear the personal consequences of a conviction. Moreover, frequently, it will be the defendant and the defendant alone who knows all of the relevant facts and who will appreciate the significance of a particular item of evidence and whether it is exculpatory or incriminatory. There is a value and an interest in the defendant being able to freely review the evidence against him on his own time and without a defense lawyer or anyone else looking over his shoulder." So they argue this is unconstitutional, that the defendant has a right to full access to this material in order to properly prepare a defense. But then the defense does something interesting in their letter. They do something else. They reference the case of accused child sex trafficker Jeffrey Epstein, one of the most infamous people ever charged with sex trafficking in New York. Quote, "Even in the high-profile case against Jeffrey Epstein, which involved allegations of child sexual abuse, the protective order didn't include a provision designating some material attorney's eyes only." And Oren's lawyers say, look, they are willing to work with the prosecution on a more narrow protective order, but they just can't agree with the current version. Quote, "The defense must know precisely what the government seeks to protect, the volume of that information, and to what extent the government seeks protection. Without such knowledge and without access to the discovery, it is difficult, if not impossible, for the defense to propose any sort of counter order. The proposed protective order would inhibit the defense's ability to identify helpful witnesses and to conduct a thorough and confidential investigation. It would also substantially block the defendants from participating in their own defense, thereby hindering their efforts to defend themselves at trial. This poses substantial logistical and constitutional burdens, and the government's request should either be rejected or substantially narrowed." Now, another document was also filed on Friday, but the only information available about it is that it is sealed. So no word yet on when we might receive a decision from the judge or response to the defense's assertions from the prosecution. I'll tell you what we do know. We now know when this federal case will likely head to trial because in a brand new order, the judge has set the trial date for January 5th, 2026. So that means pretrial motions will be due in May. Obviously, this can change, this can switch, but right now, that is when we can expect these brothers to go on trial. Keep an eye out for any updates in this case. This is one we want to consistently and constantly follow for you. A lot of different moving parts. But that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.